Thank you. Colleagues, I would like to thank swisspeace and the task force, as well as the archives and dealing with the past project, for inviting me to speak on the archives of transitional justice mechanisms. I, of course, am not an archivist and have learned over the last 30 years that archives are an imperative when one actually deals with this kind of work. I'd like to start by telling you a story of a doctor an army medical doctor, Hosaka Akira, who was attached to the 3rd Infantry Battalion of the 20th Regiment, 16th Division in the Shanghai Expedition Army. He kept a diary which in total consisted of 56 pages in a notebook that fitted quite easily in his pocket. The diary begins on August 24th, 1937, when mobilization was ordered at 4 p.m. It ends on December 7th, a day when fighting lasted from morning till night and soldiers became very tired. At that time, Hosaka's unit was in the vicinity of Nanjing, the capital of China, which would fall a week later and subsequently drew world attention for the massive atrocities committed there by Japanese troops, an event widely known as the Rape of Nanking. Roughly a week before, the diary ended abruptly. Hosaka recorded the following. At 10 a.m. on the 29th of November 1937, we left to clean out the enemy in Shangzhou, and at noon we entered the town. An order was received to kill the residents, and 80 of them, men and women of all ages, were shot to death. I hope this will be the last time I'll ever witness such a scene. The people were all gathered in one place. They were all praying, crying, and begging for help. I just couldn't bear watching such a pitiful spectacle. Soon the heavy machine guns opened fire, and the sight of those people screaming and falling to the ground is one I could not face, even if I had the heart of a monster. War is truly terrible. In late 1945, Hosaka sent the diary by registered mail to Colonel Alva Carpenter, who was the head of the legal section of the Supreme Commander for Allied Powers. He left his return address on the envelope, and to make his handwriting legible, Hosaka copied the November 29 entry in clearer handwriting on a separate sheet of paper, which was then attached to the opposite page in the diary. Of course, the Tokyo War Crimes Tribunal investigated the atrocities committed by the Japanese army in the rape of Nanking. And I think this demonstrates, in a sense, how records can become an absolutely critical part of founding indictments, particularly for war crimes. Now, archiving and disseminating records of past atrocities in societies emerging from periods of conflict or repressive rule advance the rights of victims to the truth. They also promote broader social goals of accountability and historical truth, and documenting mass abuses during and after political transitions raise incredibly difficult questions of law and ethics. Who should collect? Who should organize and disseminate official documentary material? How can documents best be used to promote goals such as accountability, truth, and societal reconciliation? And in what way could those very uses actually conflict? Now, the legal and normative justification for promoting and protecting human rights archives rest largely on the concepts of the right to know and the corresponding duty to record, flowing from the Joannet-Orentlicher principles to combat impunity, and which lay the basis for dealing with the past. The Joannet-Orentliche principles provide for the right to the truth, the right to justice, the right to reparations, and the guarantee of non-recurrence, and also elaborate how archives can be used to advance memory and justice. In a study carried out by the Office of the High Commissioner for Human Rights and submitted to the UN Human Rights Council in 2009, the OHCHR emphasized the crucial role of archives in implementing the right to the truth, the need for states to preserve government records at all levels, and to accept relevant non-official papers, as well as to establish laws governing privacy and access, and the establishment of mechanisms to promote and manage documents effectively. The duty to record, of course, obliges states to maintain an effective archive of past abuses and really requires inventorying, organizing, and preserving documentary materials, as well as developing access rules and guidelines that promote dissemination consistent with the legitimate aims of security and privacy. But for those of us who work with many states and with many civil society organizations, we know that these obligations are difficult even for wealthy democratic states to manage, let alone fragile states emerging from conflict, and who also have a host of other priorities to deal with as they emerge from conflict. And of course, resources and funding, technical skills, all of these are quite critical. Archival efforts, of course, often begin in legal and political gray zones before an old regime has been ousted or before a legitimate new government has taken shape. In other cases, often the shredding machines are extremely busy, and certainly in my country, in South Africa, on the eve of the transition, the former regime was busy trying to shred as much of the official government records as possible. And it was really civil society organizations who brought an application to stop the shredding, but nevertheless, shredding still continued. A challenge, of course, for the international community is what to do when a state is unable or unwilling to carry out its duty to record. Do other actors have the right or even the responsibility to step into the breach? Of course, over the last 30 years, we have seen the proliferation of many transitional justice institutions, ranging from Latin American truth commissions to the ad hoc tribunals for Rwanda and the former Yugoslavia, the Special Court of Sierra Leone, the South African Truth and Reconciliation Commission, followed by the more than 30 other truth commissions which have been established under national legislation or under the auspices of the United Nations. All of these bodies have accumulated a formidable array of records gathered through their information and investigative processes, as well as their record keeping. As these bodies complete their mandates, a key preoccupation for the international community and domestically is what is to happen to these records. How will they be protected and stored? Also, how will they become accessible to citizens? And how will the rights of individuals to privacy be protected? The protection here of the identity of victims and witnesses is as critical as is the preservation of evidence. Record keeping and the preservation of records, as well as how to use them effectively in transitional justice processes, is a challenge. Here, of course, the 2009 OHCHR report is useful as it alludes to the importance of provenance and original order when discussing the use of records. The first step, of course, is to understand how the repressive state worked. Then there is a need to understand three aspects of each entity whose records it plans to use: the structure, its functions, how it performed, and how the records were created as it carried out its functions. And this is certainly true whether the records are of a government department or an opposition group or a paramilitary body. And understanding the structure and functions help to judge the probable authenticity and the reliability of documents that may be used as evidence. A further key to sound documentation is related to the principles of provenance and original order. Can we trace the chain of custody of documents? And for many of us who carry on doing investigations, this is a key issue because a clear chain of custody will lead to the possibility of a successful conviction. Another example of this was at the end of World War II. Allied armies recovered a large portion of the written or filmed evidence of the Holocaust and other forms of Nazi persecution. Allied prosecutors used newly found records in numerous war crimes trials. And of course, governments released many related documents regarding war criminals during the second half of the 20th century. A small segment of American-held documents from Nazi Germany about Nazi officials and Nazi collaborators, however, remain classified right up until the 21st century because of government restrictions on the release of intelligence-related records. Mo spoke also about the trial of Yasmins, and of course we all know that this month he was sentenced by a Guatemalan court who found him guilty of genocide and crimes against humanity, sentencing him, of course, to 80 years in prison. The judge, Yasmin Barrios, said, "We are completely convinced of the intent to destroy this particular ethnic group. The guilty verdict was historic for the people of Guatemala and all those who struggle against gross human rights violators, as Yasmins becomes the first head of state tried and convicted of genocide, not in an international court, but in a domestic court." And this is a real victory for complementarity. Of course, this trial would not have been possible if the police archives of Guatemala had not been located and preserved, and the role of the federal government and the Federal Archives of Switzerland in housing and preserving these archives, as well as the project to organize the Guatemalan police archives, illustrate how core archival principles lay a solid foundation for the future deployment of documents in the courtroom. And it's interesting to go back to 2005, when the Guatemalan human rights prosecutor, Sergio Morales Alvarado, responded to a complaint from residents in a Guatemala City neighborhood about explosives being stored at a local police station. The authorities agreed to transfer the weapons, and when Morales arrived to verify their removal, he in fact discovered a vast archive belonging to the Guatemalan National Police, an organization that was centrally involved in the country's brutal civil war between 1966 and 1996. Morales, of course, quickly obtained a judicial order enabling him to search the documents for evidence of human rights abuses. An initial review suggested that the archive contained information on many of the high-profile assassinations and disappearances in Guatemala. But a human rights investigator, Kate Doyle, who assisted the project, describes the scene vividly. She says, and I quote, "On every available centimeter of the cement floor, there were towers of mildewed paper and file folders, tied in twine and entombed in grit. The paper was decomposing before our eyes. Wet paper, rotting paper, charred paper, paper brown with mold, paper becoming compost with small seedlings growing through it. The stench of decay was overpowering. All around us were insect carcasses and bat droppings, feathers, bird shit, and the nibbling of rats. We stepped gingerly over haphazard trash heaps, which on closer inspection included thousands of black and white photos. The prosecutor's office was sweeping them into piles and transferring them into clear plastic bags. Millions of documents were strewn around the building in that state of decomposition and human rights and disarray. Of course, the discovery made national news. Local human rights groups offered volunteers. Foreign donations helped the prosecutor hire dozens of staff. But it was really the work of people like Trudy who ensured, in fact, that staff were trained, the Documents were in fact preserved. And of course, today we see not only the prosecution of 2 Guatemalan policemen for the abduction and disappearance of Fernando Garcia, a student labor activist, but also the conviction of the former President Yasmins. And I think this really is a triumph for the archival community. What it shows is how effectively archives can become a real tool for those who do this kind of work. Of course, the preservation of documentation of archives also remains a key challenge. They need to be protected from theft or human-inflicted damage, as well as physical degradation. Legal sanctions must be in place to deter theft or deliberate destruction. Archives, of course, also need to be physically protected, and that usually means relocating them to a facility that has a reliable security presence and putting older materials in files or cabinets that offer protection from other elements. But there's a key question. When a country has competing priorities, the needs of its citizens, where does the protection of archives and the preservation of documents actually fit into that scheme? And that really raises questions of how one protects national sovereignty, but at the same time, is it possible to help countries by storing secondary reports in other countries? And this is what certainly happened in respect of the Guatemalan archives. One of the digitization efforts that help to preserve and disseminate documents can also help in the process of analyzing them. And this was certainly true in the Fernando Garcia trial, where Daniel Guzman from Benetech provided expert evidence testimony presenting a statistical analysis made possible by the bulk scanning of the documents that showed a disproportionately high percentage of documents related to the Garcia case, which had been sent to units responsible for directing and coordinating the national police. And so, of course, this is something we also need to look at, new technology, and how that helps us in our efforts. In the case, of course, of the ad hoc tribunals, the Security Council in September 2010 decided to establish the International Residual Mechanism for the criminal tribunals to finish off the remaining tasks that they have, and of course to maintain their respective legacies. A huge part of this is, of course, their archives. In terms of Article 27 of the resolution establishing the residual mechanism, this of course deals with the management of their archives. And Article 27 provides that the archives of the 2 tribunals and the mechanism remain the property of the United Nations. Now this of course in the face of countries like Rwanda arguing that in fact it belongs to them. The archives, of course, shall also be inviolable wherever located pursuant to Section 4 of the Convention on the Privilege and Immunities of the United Nations. It also provides that the mechanism shall be responsible for the management, including preservation and access of these archives, and that in terms of the location, the archives of the ICTY and ICTR shall be co-located with the respective branches of the mechanism. A key point, of course, is that in the management of the access to the archives, the mechanism should also ensure the continued protection of confidential information, including information concerning protected witnesses. And of course, this is a key issue because all you need is for somebody to be bumped off because people were not careful about how these archives are handled. It also provides that the mechanism shall implement an information security and access regime, including for the classification and declassification as appropriate to the archives. A key challenge for all of us, of course, is question of resources, technical skill, and the big question for developing countries, funding. An example for me is, of course, that the Truth Commission in Sierra Leone, nobody thought about what would happen to the archives right up until the last moment. And at that point, the government of Sierra Leone made some money available for the organization of the archives. Ultimately, of course, The archives and the records were deposited at Forabay College, while we had indicated that ultimately ownership of this should rest with the Human Rights Commission when it was established. We were happy that we would leave it to a new body. We were satisfied that, in fact, it would be taken care of by the Human Rights Commission. But of course, the Human Rights Commission determined that it should become part of the records of the new Peace Museum, which was established by the Special Court of Sierra Leone as part of its legacy project. The Human Rights Commission and the Peace Museum concluded a memorandum of understanding with the Special Court. The Peace Museum consists of 3 parts: the archives, which include the public records of the court, its library, the TRC records, and also additional records from the peace process from other organizations. The MOU, of course, defines the tasks and responsibility of the Peace Museum. The records of the TRC are supposed to be accessible for research and educational use by other organizations, but in reality, they're only accessible to the archival staff. And while we said that the Human Rights Commission should regulate access to the archives, this is no longer a priority for the government of Sierra Leone. And now that the funds are exhausted, it is unlikely that in the long term, funds will be made available to make the archives viable and accessible. Sadly, this situation reflects what is probably a concern for many, many governments across the world. And people like Catherine from SAHA will tell you that even in a well-resourced country like South Africa, we still grapple 15 years afterwards for access to our own archives. Victims have to go through laborious processes to access their own records. A further gap or challenge is also the absence of mechanisms to collect, document, preserve, and protect evidence once a commission of inquiry or body has come to an end. While the documents collected during the lifespan of such institutions will be protected by the UN, if these structures were established by the UN, nothing actually exists to deal with ongoing issues thereafter. Now, this, of course, poses a huge challenge to ongoing investigations, particularly in respect of serious crimes under international law. Preserving the evidence collected, maintaining the integrity of the chain of custody is critical. How many of us know of botched prosecutions simply because the chain was not preserved? This is an area that really needs discussion, and I hope that today this is something that we can discuss. We probably need new strategies which could lead to concluding agreements with willing governments, with willing national archives of state, and with prosecutors to ensure the documents that are collected are preserved and protected, and that we are able to enter into agreements to protect the chain of custody. In this kind of vacuum, of course, non-state actors could play a key role. NGOs have the right and even the responsibility, when states lack the will, the capacity, or the legitimacy to document past abuses effectively. In this regard, Cambodia provides an illustration of an NGO-led documentation officially authorized by the state. In 1979, invading Vietnamese forces discovered troves of documents containing important information about the Khmer Rouge reign of terror. Much of these documents later became part of the archives of the state-run Tuol Sleng Genocide Museum. Many more documents were simply locked in a dark room in the Ministry of Interior of the People's Republic of Kampuchea, the Vietnam-backed government that replaced the Khmer Rouge. DC CAM, which had been established by Yale University's Cambodian Genocide Project, obtained these documents from the Ministry of Interior in 1995. At that time, the Cambodian National Archives were underfunded. They were lacking in capacity and in a state of serious disrepair. The documents in question had essentially been untouched since 1979, and nothing had been done to organize or to preserve them. Many were documents printed or handwritten on poor quality paper, and had deteriorated considerably since their creation. And in that context, engaging an outside actor with the funding and expertise to set up an archive was imperative. The government authorized DCCAM to establish an archive by issuing a letter. And of course, in the absence of an archival law, the government's letter of authorization functioned like an administrative degree. A small number of critics, of course, argued that it was illegal for the government to transfer the documents to a non-governmental entity. But DCCAM's in-country presence and the government's explicit approval of the arrangement satisfied most concerns. DCCAM was able to develop an extensive archive with support and funding from diverse international partners. The collection remains in Phnom Penh and has been instrumental in a wide range of initiatives aimed at memory and justice, and has played a pivotal evidentiary role in the UN-backed Khmer Rouge Tribunal, and has served also as the foundation for an array of other research and education projects, particularly on a nationwide genocide education program. The government, of course, donated a parcel of land to DCCAM for the purposes of establishing a permanent documentation center. I think this example illustrates that specialized archives need not, in the absence of capacity or legitimacy, be run by government agencies. But of course, it is absolutely critical to have the blessing and the active support of the state concerned. The Cambodian model, of course, is an appealing model, while national institutions are still in a gestation phase, or while a new government's credibility on human rights issues is still in doubt. It can also be an acceptable longer-term outcome where the government grants consent and the non-governmental entity is able to perform archival functions as well. But in the wake of mass abuses, I think all of us can agree that archival information clearly has a powerful impact on accountability proceedings such as criminal trials, truth commissions, and commissions of inquiry, as well as the many wide range of transitional justice mechanisms. That potential has since been clear since Nuremberg, where documents and films played crucial roles in the conviction of Nazi criminals. Archival materials have been central in a number of high-profile cases. General Pinochet, the Garcia trial, Rias Mont trial, as well as the trials of the Khmer Rouge leaders in Cambodia. And I think that really provides for all of us an important strategy for how we go about our work. So I hope that in what I have said today, this has laid the foundation for, I think, a compelling discussion today. There are many gaps, and we certainly need to talk about how to address them. Thank you. We would now like to open the floor and maybe do I need to stay?
Questions from the audience? Thank you very much, Professor Mahiner. You described the challenges in Sierra Leone and South Africa in terms of access for victims and others to the archives and the other commissions, but it seems as if there's always going to be natural tension between the struggle for access and the demand of confidentiality. And in many ways, this puts the greatest burden on whether it's a truth commissioner or other inquiries or tribunals that are doing the investigations work. So how does one balance that? How does one balance that so that one can both advance to the greatest degree level of access to the trial for victims and rights advocates and others, as well as heightening the trust that victims and others can have in the system, that when they provide that information, that they don't put themselves at risk by that coming out later. So your reflections both on those specific cases where you were most close to the processes and watched them after the fact, as well as the many others that you've been involved in. Thank you very much. more questions? Otherwise,
I think you describe in your intention, and often that tension is also because the state always asserts that it has not just the question of the right to the privacy of victims to think about, but also I think security concerns on the side of the state. I do think that states can overcome that problem by certainly passing access to information laws, which also set out criteria in terms of which those considerations can be balanced. I do think, however, that what my experience has certainly been in South Africa is that almost from the inception of the work of the Truth Commission, this was a big problem in South Africa, and it didn't start with just with the rights of victims to access archives, but the archives of the Truth Commission. But I just think back to a very important consideration in the work of the Truth Commission in South Africa was accessing not only the archives of the former state, but also accessing the archives of the National Liberation Movement. And accessing both sets of records were, quite frankly, a nightmare. In one instance, one of our really enthusiastic investigators mounted a raid on the military archives without giving them notice. And of course, the head of the military and the defense minister immediately called the president and the two deputy presidents at the time. And the commission was placed in this really unfortunate situation of having to really take a step backwards. And I think what was a mistake, of course, is the military then proposed a deal in which they would appoint nodal points through which the commission could then file applications for access. And what that later became was simply one more mechanism to block access to the military archives, and this really became a problem later on. And in fact, what the commission learnt about the military didn't come from the military themselves. It actually came from joint military police operations, and that was the way we learnt about the military. But interestingly enough, the ANC had a remarkable repository of archival material, but even they were really problematic around accessing their documentation. And of course, you remember large numbers of people had gone into exile, people had been fighting from around the surrounding border areas. And so when one wanted to establish whether or not someone had died in exile, or when you wanted to confirm a disappearance, you would have to go to the ANC documentation through their documentation processes. And this was, of course, extremely difficult because you would be fed information rather grudgingly. Of course, a very important moment for the commission was when they handed over the secret hearings by the secret military structures. And that way we, of course, learned a lot about what had happened in the executions that had been done at the hands of the military. But later on, in the life of the commission, there was a point, almost at the end of its lifespan, when 34 boxes of material was removed from the archives of the Truth Commission and handed over to the Minister of Justice, who then sent this to the National Security Minister. And this was done under the misguided notions, really, of the executive officer of the commission, who at the time thought that there were people outside of the commission trying to take ownership of the archives, and under the misguided notion that he had to protect the integrity of these records, which belong to the state in his view. It belongs to the people, not the state. He then handed these boxes over. And it took us, I think, a very, very long time to get those boxes back. And when they were returned, clearly there were really important files that were missing from the boxes.
And in some instances, there had been the redaction of quite important information in the files. Now, you must remember this was while the Truth Commission was still in its final phases, and so that was really a problem. The Commission, of course, did indicate in its recommendations that, you know, there should be some kind of national dialogue on how the archive should be managed. Quite frankly, I mean, this has been since 2003, an ongoing discussion with the government. And even though we have an Access to Information Act, we have a Just Administrative Act, I think Catherine will explain to you how difficult the process is to actually extract records from the Department of Justice, who today remains the custodian of the archives, even though they are housed at the National Archives. They're in a poor state, disorganized, nobody's paying attention to it, and it's just not a priority to get this off the ground. And I must say that part of the tension is also because even though we moved from a very liberal environment in the 1990s of an open society, increasingly over the years, security issues and the security establishment have become fairly dominant. So much so that last year the state tried to push through Parliament a bill protecting some information on the basis of security concerns, and not, you know, and this was quite draconian legislation. Now, of course, in the last few weeks, this bill has finally been passed by Parliament. Yes, it contains some of the input from civil society around raising public interest as a defense, but it's done so in a very limited way. And it's quite likely that this protection of information bill is going to be challenged in the Constitutional Court. You know, sadly, I think what's really incredibly difficult in the South African situation is it's easier for an international body or an international researcher to get access to our archives. They can pay for it. But if you're an ordinary citizen, you have to jump through hoops. You have to pay a lot of money. And there is no ombudsman like you have in places like Ireland. And so these are long and cumbersome processes. Having said that, of course, I think that given the experiences of many archival projects across the world, working out the rights of, you know, and the rights of victims and the protection of the identity of key people, I think these can be balanced. There are enough examples around the world to do that. I think the real tension lies between those who are the securocrats in any country and ordinary citizens who should, quite frankly, be able to access their own records. You know, 2 years ago, we discovered that I think Yale University had a complete set of all the video material and electronic material. But in South Africa, ordinary victims in universities didn't have that. So, you know, at the foundation where I worked, we purchased a copy. Never mind that we had raised the funding for the national broadcaster to, you know, to televise the proceedings of the Truth Commission. But nevertheless, we had to pay commercial rates to get copies of the material so we could hand that over to the History Archive so that at least our own records can be accessible to ordinary citizens. So it's a long battle. We haven't won it yet, but I think security tensions are one thing and balancing, obviously, the needs of the state. But I think the other question is also funding and capacity. And I think on the capacity question, one can certainly help many states. The problem is, of course, also sovereignty issues, often a position that, why do you want to take away our archives? You know, this is our knowledge repository. And I think in those instances, what happened with Guatemala, which is to make a secondary record, I think is a very useful way of helping a country, both in the long term and, of course, in the short term.
Thank you. More questions?
Hello, my name is Anna Katulu. I have a question. Isn't it a risk that victims and witnesses might not be willing to participate in the international mechanisms because I've been working in ICTY and ICC, and whether it's the calling party, whether it's the defense or the prosecution, also legal representatives representing the victims, we inform the witnesses and victims what, in terms of protection mechanisms, in terms of what kind of protective measures there is, that they become basically witnesses of the court once they do testify. But we can't really say what happens to the archives afterwards and who will be there to preserve their rights. So in a way, from my own experience, it's already difficult to convince, especially victims, but also generally witnesses, to participate in those mechanisms. But we can give them certain guarantees in terms of their identity being protected, etc. But once it's potentially out of the mechanism's hand, when there is a closing down of the STY, etc., or other transitional mechanisms, isn't there a risk that it might scare off witnesses and victims?
I think that's a really important question, and I think one of the things I would say is that one has to be absolutely scrupulously honest with victims and witnesses about exactly what extent the protection is, because what you really don't want is for someone to be harmed because one was not careful or honest about it. But what I can tell you is that when we sat on the work of the panel for Sri Lanka, we knew that one of the first questions we would be asked by people, they were putting themselves at risk by traveling to meet with the panel. And what we went to the UN legal office to do is to actually ask what kind of protection mechanisms can be put in place to ensure that the archive is in fact secure and protected. And I think you need to establish that up front. I think it's a lesson, because these are certainly not things we thought about when we all began our work. I think it has, when the due date was coming up for the closing or the end of the work of that tribunals, suddenly there was this panel that was going around the world asking people what they thought about what should happen. But it's probably the first time that it really hit them, that the moment will come when you have to start thinking about what you're going to do with all your records. And this is certainly true for many commissions. I don't remember thinking about the archives until probably 2 weeks before we were going to hand our report over. And that was the first moment in the commission when we actually began a discussion on, so what should happen to it? And what's sad about that is then you don't put in place the kind of arrangements you need to make with the right authorities to ensure that that happens. And of course, if you do that up front, like we did with the panel, we were able to say to the victims who came forward and witnesses exactly what we could do and what we could provide. I think witness protection is a really key issue. Security is a key issue when you're talking about serious crimes under international law. And you really have to make sure that you're not messing around with people's lives. Of course, it's easy to say that, having been through a number of structures where, to my own cost, I have realized what it means when you don't pay attention up front to these issues. And so that's really a lesson learned. But I think any body that works in these kind of structures, one of the first issues you should put on the table is, what are we going to do about the information we collect, the records we begin to gather? How are we going to protect them? How will we define who should have access to them? And what structure will be put in place to make sure that you manage that? I think that's now a fundamental thing that one has to do. And I think this is where the High Commissioner's report of 2009 is really, really very useful, because I think it's based on discussions that have been held with archivists working in many different projects, that it's a very practical document in terms of many of the challenges that all of us experience. A key point, of course, is that if you can't protect victims or witnesses, then I think from a responsible perspective, we shouldn't really take their testimony. I think the big rule should always be do no harm. Huh?
Thank you. There are more questions? Yes.
Thank you. Bryony Jones from swisspeace. I'm very interested in the aspect you mentioned in regards to Sierra Leone of the removal or transfer of, say, Truth Commission archives into larger peace museums or places of memory. And I just wanted to know your thoughts on whether you think the archival questions are different, or in fact maybe should be different, when you know that the archive itself is going to become part of a much bigger active attempt to construct a particular type of memory or story about the past, and whether you have any thoughts on that from your experience.
Let me say, I think that firstly, I have a problem with the transfer of the archive to the Peace Museum, because I think that the Commission was very clear. There should only be two bodies who would have access to the archives, because remember the reparations question was still outstanding. And we were quite explicit that the newly formed Human Rights Commission should have ownership, and that NACSA, the body that was tasked with implementing the reparations policy, should then be able to access the records of victims, but only after the Human Rights Commission had really dealt with all the questions which I think Priscilla raised: rights of privacy, the protection of witnesses. Now, when you have an archive like that transferred without any of those questions being answered, and it's then transferred to a structure which has actually a very different purpose to that which the National Human Rights Commission would have held it for. I mean, this is a Peace Museum is looking at how it's going to use those records. I don't see, when I read the MOU, that it makes provision for that kind of different activity. So I think this is an area that does need some intervention. Otherwise, I think you could, there are also the questions of whose history does it tell? How's it going to tell that history? And I think that's a very, these are very important questions, because those who win always like to tell the story their way. I mean, this has been a challenge even in my own country, where for a long time it was only the history of the liberation movement which really excluded the stories of many, many other people and institutions that were part of the struggle for freedom, and we're playing catch-up on that score. And so I think these are really tricky questions. I would like to see that there's a national dialogue in Sierra Leone with historians and social scientists and people who have a key ear for this kind of thing, where they should discuss this and actually form some kind of joint task force that can manage this process, because I think it's a really tricky issue, and of course once there can be quite dangerous in the hands of people who haven't really prepared properly for this to happen. So actually I think it was a very carelessly managed decision. Yeah. Thank you.